So hopefully you're seeing our initial slide, Child Custody 101. We're going to be talking about modification and enforcement of judgments. Last time we met, we talked about establishing custody and establishing support and what have you. But today we're going to talk about what happens when you have a order and somebody's not following it, what you can do, or if you want to make changes. So let's go ahead and start. Our disclaimer, of course, this presentation contains general information, does not constitute legal advice. Please be sure to direct specific questions about your own situation to an attorney. So what will we be covering today? Well, today we're going to talk about modifying custody or parenting time orders. We're going to talk again about enforcing them. What do you do if somebody is not complying with your existing custody order? How do you have that enforced? And hopefully at the end, if you have any questions or need additional help, please do so. Again, I really try to answer questions on the fly if possible. So again, please feel free to ask your questions in the comment section underneath the presentation. But if you do ask questions there, keep them very general in nature, because we don't want to destroy your confidentiality. You're always free to send us a direct message here on Facebook. That's a much more confidential way to reach out to us. But again, if you want to ask me something as we're going on, I will do my absolute best to do that on the fly. All right, so post-judgment modifications in New Jersey custody orders. Sounds fancy and daunting, but it's really not. We're going to talk again about how to change those existing custody orders for you. All right, so post-judgment modifications. What if things change after a quote-unquote final custody order? Now, it's important to note here, because we get a question a lot. That is, well, listen, I was just awarded temporary custody. How do I make my custody permanent? Well, quite frankly, there is no such thing here in New Jersey that talks about permanent custody. There's no such thing. All custody in New Jersey is temporary. Why is that? Well, that's because, as you see here, child custody orders can be modified until the children are emancipated, deemed to be independent. They're outside of what is called the sphere of their parents' influence. If a child no longer needs their parent for support, then they're deemed emancipated, and custody orders go away, child support orders go away. So because of that, because people change, children grow, people move, all custody and parenting time orders are temporary in nature. Now, if you want to go in and change a custody order, there has to be a substantial change in circumstances since the last time you were in court and the order was put in place. What does that mean? Well, it can't be a minor change. You can't go from having one overnight a week to two overnights a week and then run in and ask for a change in custody. There has to be really something substantial going on. Perhaps what you and your child's other parent have been doing is you've gone from you having only alternate weekends to now you have 3 days a week, 3 overnights a week every week. Or you now have 4 overnights a week and your child's other parent only has 3. That's a substantial change in circumstances. Now we're kind of going from custody that's one parent of primary residence to almost a shared physical custody situation. And if that's what's been going on, you do want to go back into court and change the order so that it appropriately reflects really what's going on in your life. As always, the court will expect parents to try to work things out through negotiation or mediation before going to court. So, if you two are able to co parent effectively, if you're able to sit down with each other and hammer out things that have come up since the last time you were in court, do that. You may need the assistance of a mediator. Perhaps you used a mediator to come up with your initial court order. It's important, really, really important for you to try to work things out. The court is going to expect that you do it. And quite frankly, you want to have control over your custody orders going forward. Why would you want a judge who is really a stranger laying out your custody and parenting time plans for, however many years going forward? So always a good idea to sit down, negotiate, mediate before going to court. All right, post-judgment changes. What is a substantial change? Well, again, there are some potential triggering events. Has to be substantial. As we just described a little bit a couple seconds ago, a decrease or an increase in parenting time. Perhaps there's actually been a change of the primary residential parent. Kid goes from one household to the other and is now living with the other parent full time. Or a change from sole custody to joint custody, or vice versa. So if one parent was awarded sole custody, but now you've both agreed that you want joint custody, either legal or physical, you want to go back into court, you want to amend your order so it reflects what's truly happening in your life. Courts considering a request for a major change will require proof that whatever change it is in your child's best interest. Child's best interest is that overarching umbrella where the court must consider any decision with regard to child support or parenting time to be in your child's best interest. If what you're asking the court to sign off on is not, then the court's not going to agree with you. So make sure that whatever change you're doing is in your kid's best interest. This is usually not an issue because, of course, parents want what's in their child's best interest, but it could be something that perhaps you're not thinking about. For example, you want to have shared physical custody of your 4-year-old child, but you and your child's other parent live 3 hours away. One is in Alpine, the other one is in Cape May. Well, that might not be in the best interest of your child to be in the car that frequently. So again, think about what's best really for the whole family. What about move away cases? We also know these as relocation cases. So the parent of a minor child who's born right here in the Garden State can't leave the state with the child without the permission of the court or permission of the child's other parent. So under old law, a parent wishing to move with the children needed to show that the move would benefit the child. But that law's really been supplanted. It's not the law of New Jersey anymore. The current law is the parent wanting to relocate with the child can move if the reason is a good faith reason for the move. That the parent's not moving to keep the child away from the other parent, and the move can't be harmful to the child. Again, this doesn't really come up a lot. Most people want to go where it's better for the child. They don't want to move to where it's worse. So 9 times out of 10, there's a good faith move, and the move is, to a place that is at least as good as where they're living already in New Jersey. So what about moving if you have joint custody of your child with your child's other parent? Well, having joint legal custody isn't really sufficient for the court to step in and say, okay, we have to now review custody from the beginning because mom's moving with the kid. Joint legal custody is not about day-to-day where the child is physically. Legal custody is more about decision making. So having joint legal custody is not going to trigger an entire review of custody by the court. But if the parents have true shared custody, meaning an equal or nearly equal division of time, Also coming with that is obviously equal division of parental responsibilities. Then the parent who wants to locate must demonstrate that it's in their child's best interest for the court to change custody and then make that parent the parent of primary residence. So here, by virtue of moving, it can't be shared custody anymore. So now that moving parent has to go back into court and say, not only do I want to move, but I need you to change the custody arrangement so I'm the parent of primary residence. So only after that hurdle is crossed will the good faith and the lack of harm standard of relocating will be considered. So the first thing the court has to consider is it in the child's best interest to go from shared custody to move away parent having custody? And once that hurdle is crossed, then the court will look at the good faith and lack of harm standard for the move. What is a good faith reason for the move? Well, really any reason that's genuine and not motivated, again, by the desire to keep your child away from the other parent. So examples, job offer, new spouse's job offer, perhaps there's an anticipated remarriage to a person who is really tied to a different community or state, or being closer to extended family members. Perhaps your child's other parent isn't from New Jersey, and now that you two are separated, he or she wants to go back to wherever it was that they came from in order to be closer to their extended family members. So in a relocation case, what are some acceptable alternative parenting plans? Now, obviously, if you're at this point before the relocation, having your child, every weekend, Friday to Sunday, and one night during the week, and your child is going to be relocating to California, well, that's not going to be feasible. So how do we come up with an alternative parenting plan that keeps up with the quality of time, maybe not necessarily the amount of time, as close to the amount of time as possible, but how do we come up with a parenting time that really is beneficial for the entire family? Well, typically you need to start thinking about having your child with you during chunks of time. So for holidays, such as winter and spring break, over the Christmas holidays, and for a good amount of time during the summer break. If not the whole summer, perhaps you each have a month in the summer. Again, you have to specify a reasonable method of transportation for your child and figure out who's going to pay for it. So again, if we're talking about, New Jersey to Massachusetts, it's going to be a lot less costly and burdensome to get your child back and forth than if we're talking about getting on an airplane and flying cross country. So think about who's going to pay for that, how your child's going to travel. Is your child old enough to travel on their own? Will they need, like an airline companion? Will another parent have to travel with them, and who's paying for that? So more things for you to think about. The parenting plan should also specify additional methods of contact. This is really important because as technology is becoming more and more advanced, look at us today. I'm coming to you from my laptop here. Courts are encouraging more and more alternative types of contacts like email and texting and Skype and other kinds of virtual parenting time. There actually was just a study that was done in 2015 regarding parents who spend time with their kids via Skype. And everyone who participated in the study found that that kind of communication was really very beneficial to everybody and was sort of a warmer means of communication than typical phone contact. Now, here's what's important. Your plan, if you're the one relocating, you have to realize that the plan has to actually work for the parent who's remaining here in New Jersey. You're the one who's moving. Try to be reasonable. Think about, costs and what can work for the parent who's remaining here. You also want to think about perhaps having an open door policy with fair notice and fair warning for your child's other parent to come to wherever you're moving, and they're welcome to have open access to the child when they're visiting the new state. So what happens if you're opposing your child being moved out of state by their other parent? Well, the first thing you want to do is demonstrate to the court that you have shared custody of the child, because again, remember, that's that sort of two-pronged test, and the first burden that the moving parent has to show is that even though there is truly shared custody, changing it to a different form of custody is in the child's best interest. If there is a lack of good faith, if you truly believe your child's other parent is moving to keep your kid away from you, or if where the child is moving is unsafe or is not healthy, or they're not going to be afforded services that they may need that they're getting here in New Jersey, bring proof of that to the judge. In either case, you really do want to focus on your relationship and how close you are with the child, and how your child would be adversely affected by the move, by your inability to continue in your current role at a distance. There's no arguing that your parenting time is going to change, and your relationship is going to change with your child if your child is moving away. If you feel as though your child really truly will be adversely affected by a move away, talk to the court about that. So this is the leading case when we're talking about relocation here in New Jersey. It's called Bowers v. Lewis, and there are factors that any court here in New Jersey, must look at when deciding whether or not to permit a parent to relocate out of state with a child. All courts look at this case, and they call them actually the Bowers factors because they've been so common and so commonly used by all the courts here. Any good family law attorney is going to know when you come to see them that you want to relocate, let's look at the Bowers factors. So here they are listed for you. I'm just going to go through them briefly. Again, the reason for the move, the reason why the other parent is opposing the move, what your past interactions have been like between the two of you, and whether you'll be able to co-parent from a distance, whether the move, again, will afford your child the same health, education, leisure opportunities, if your child has any special needs or talents that may or may not be accommodated in the new state, the availability of a satisfactory visitation and communication arrangement that will allow, again, a full and continuous relationship. How are we going to do that? That's why the parenting plan is so important, for you to lay out how your child is going to see their other parent and those other sort of alternative modes of communication. The more exposure, the more communication, the better. Continuing with the Bowers factors, the likelihood that the custodial parent will foster a relationship between the child and the parent who's staying here in New Jersey. The effect of the move on extended family relationships. What if the child's leaving all, for grandparents here in New Jersey, and the child is very bonded with the grandparents? What's going to happen to those relationships? The preferences of the child if of sufficient age. What is sufficient age? Well, it really depends on the kid. Usually around 12, a court will entertain what the child's preference is. But again, it depends on the maturity level of the child and the ability for the child to understand what's happening and what's going on. Whether the child is about to enter their senior year of high school. Again, some of these won't apply to your situation. Whether the parent staying here in New Jersey has the ability to relocate themselves. That might be a great solution if the parent who's in New Jersey has the ability to go to California as well, and really has that ability to, perhaps transfer their job to the new state. That's a great answer to a problem of a great distance. So consider that. And any other factor relevant every good law here in New Jersey and probably throughout the United States has this catch-all at the end. Because again, every family is unique and every kid is different, and there may be some factor that's not considered here by these others that the court should look at if they're relevant to the child's best interests. So we're going to jump from modifying or changing your child's custody order to enforcing your custody order that you have here in New Jersey. And it's really enforcing orders or agreements that you and your child's other parent may have come up with through negotiation or mediation. So what happens when one of you isn't following your order or agreement? So one of the things that we see come up as an issue is one parent interfering with custody. So parents have a legal duty to comply with any court-ordered parenting time plan, and that includes encouraging their child to spend time with the other parent. Don't badmouth your child's other parent in front of them. Don't tell them that they shouldn't go. Don't make negative comments about your child's other parent in front of your child. It's only going to serve to harm the child. And if it gets back to the court, you're not going to be looked on by the judge very kindly. So avoid doing that. Don't interfere with parenting time. Don't interfere with custody. Interference with custody or visitation can be, again, subtle behavior like not answering the phone when your child's other parent calls, not passing on emails, being late, scheduling appointments or activities during parenting time, purposefully. Keep a log, keep a journal. If this is repeated, then you're going to want to bring it to the court. Again, only in really severe cases should you consider running to the court immediately. Usually the better approach is attempting to sit down and work it out between the two of you. If that fails, then you can certainly bring it to the court. It's never a good idea to run to the court with one issue of your child being dropped off late. Again, don't overreact. But if it's becoming a pattern and practice, certainly keep a journal so you know that if the time comes that you have to go to court, you have something that you could provide to the court that's in writing. If your child's other parent is consistently going against your custody order or your parenting time, you may want to consider going to court and filing a motion, and the motion is called the enforcement of litigants' rights. You may even want to include in that a request to change parenting arrangements. Usually this comes up, we'll see this happen frequently if we have a parent who's failing to show up for parenting time and you have the kid waiting and they consistently bail out or they're late. If this is harming your child, then you might want to consider going into court and saying, listen, the parenting time plan as it is not in my child's best interest. They're not following through and my child is becoming upset. Interfering with court-ordered parenting time can be a crime in New Jersey. Yeah, it's really, really serious. And a parent who hides the child from the other parent or takes the child out of state without the other child's permission could be seen as kidnapping the child, could be seen as interfering with custody or parenting time, and may actually get a jail sentence. Now, this is really in the extreme, but it certainly can happen. So don't mess around with not following your court orders. Talking about those penalties for interference, there is a court rule. You can see the citation there, 5:3-7. In cases involving failure to comply with parenting orders, New Jersey family law judges can order whatever remedies are justified under the circumstances. Wow, that's pretty broad, right? That gives New Jersey family courts really, really a lot of strength and latitude to do what they will if they see a parent interfering or failing to comply with parenting orders. Excuse me for 1 second. I'm just going to take a sip of water. Alrighty. Continuing with penalties for interference, a court actually might order changes in parenting time or in custody if there's a repeated violation or a repeated failure to comply. Some of the penalties in that new plan might be awarding compensatory parenting time for the parent who missed, changes in transportation arrangements for parenting time. So if perhaps the responsibility for pickup and drop off was split, the court may say no, now the one parent is responsible for both pickup and drop off. Changes in pickup location, sometimes you'll see this at police stations, especially if this is a really acrimonious and angry situation. Courts don't like to have pickup and drop off at police stations because it can tend to make the child a little bit intimidated. So perhaps you could do a neutral location like a restaurant or a park. And in really, really severe situations, a change can be made by the court to custody. So if one parent has residential custody and is refusing to send your child for parenting time, and they keep doing this willfully, then the court can change custody. Some more penalties for interference. A court can also order the interfering parent to pay attorney's fees of the other parent and court costs, attend parenting classes or counseling, pay for counseling for the children or for the other parent, pay any other costs resulting from failure to follow the court order, perhaps participate in community service, or even issue a warrant for their arrest. So defenses to interfering with custody. So, the other parent may say, listen, I have a really good reason why I'm not allowing my child to go for parenting time with their other parent. Perhaps there is imminent danger to you or to your child. You're in a domestic violence situation and your child's other parent is really become violent and you're in fear for yourself or for your child. Of course, if you're in immediate danger, you can contact DCP&P. You see the telephone number there, the local police, the district attorney's office, where your child is living if you're not living with them, and let them know your child's location as soon as possible if you believe they're in danger. Again, if you're a victim of domestic violence, you might want to bring a custody action in an appropriate court as soon as reasonably possible. Contact an attorney or DYFS immediately to ensure that you're complying with the law. Again, it's reasonable to withhold parenting time if there is danger to your child, but you don't want to you want to absolutely make sure that you're complying with the law. So if you're not sure, talk to a family law attorney or talk to somebody at DYFS. A good point to make is one that you see here. Non-receipt of timely child support payments is not a defense. That is absolutely 100% true. We see this a lot. We have custodial parents saying, I haven't gotten child support in 2 years. Why should there be parenting time? The law sees parenting time and custody as completely separate from support. So you can't withhold custody, you can't withhold parenting time because you haven't received child support. Well, that's the end of today's webinar. As you see here, if you have any further questions, give us a call. Our toll-free number is 866-580-8754, or you can certainly shoot us an email. We love to get emails from potential clients, and we strive to answer you as quickly as possible. If you're ready and you want to come in to talk to one of our qualified and compassionate family law attorneys about your issue, give us a call. Schedule your confidential and free consultation. You see all of our office locations there. We are a statewide practice. So you'll undoubtedly find an office that's convenient to you. Also, visit our website. You see the website there. It's weinbergerlawgroup.com. You'll also get there by WLG.com. We have a whole bunch of information there for you, not only on custody and parenting time, but on divorce and domestic violence and relocation. Any family law question you might have, you'll find some information about it on our website without a doubt. Of course, if you want to leave your comments here about our webinar, let us know what you thought about the new format rather than the overhead projector. We'd like to know what you think. If you found value in this, please like it and share it. We always appreciate that. And again, if you have questions, feel free to direct message us here, shoot us an email, give us a call. We look forward to welcoming you again.